records are meant to show how justice is delivered. But not every decision is spoken aloud. Some outcomes are shaped by rulings and orders. Others are shaped by how long a person is made to wait without answers. These are those cases. This is what happened before the gavel fell.
After the meeting, nothing happens. Not immediately, not formally. Nothing happens in a way Daniel can point to. There is no follow-up email, no notice, no written confirmation, just silence. Daniel waits for clarification about the document he was shown. He expects something procedural, a timeline, a checklist, even a rejection. Instead, the days pass without response. When he calls, he is told the matter is under review. The phrase is delivered politely, as if it is meant to reassure him. Under review. Daniel asks what exactly is being reviewed. He is told the case status. He asks who is reviewing it. He is told the court. The answer feels complete without actually saying anything. A week passes. Nothing changes. His custody status remains the same. The interim measures remain in place. Appointments he was told might be adjusted are not adjusted. Each condition is still described as temporary. Daniel notices something then. Temporary has stopped meaning short. He sends an email asking whether a decision has been made regarding the compliance acknowledgement. The reply comes 2 days later, automated and unsigned, stating that no update is available at this time. It ends with a sentence thanking him for his patience. Patience, Daniel realizes, is being treated as participation. Another week passes. Daniel's attorney checks in and receives the same response. The matter is under review. No timeline can be provided. No action is required at this moment. No action required. But everything is still happening. The restrictions remain. The conditions continue. The assumptions hold. Daniel asks whether he should file an objection to preserve his position. His attorney hesitates. They explain that objecting now could be interpreted as resistance, especially given that cooperation has already been discussed. Daniel asks how cooperation is being measured. The attorney does not answer directly. A notice arrives in the mail, not a decision, an update. It informs Daniel that because the matter is still under consideration, all interim measures will remain in effect until further notice. There is no date listed. Daniel reads the notice twice, then a third time. He realizes something important. Delay is not neutral. Every day that passes without objection is being counted as acceptance. Every day that passes without resolution reinforces the existing conditions. Daniel asks his attorney whether there is a deadline he should be aware of. After some checking, the attorney finds a reference buried in procedural guidance, a window, a discretionary period during which objections are typically raised. Daniel is already outside it. No one told him there was a window. The silence begins to feel intentional, not malicious, efficient. Daniel tries another call. This time he is told the case is in queue, that reviews take time, that the court appreciates his continued cooperation. The word cooperation appears again. Daniel realizes the system is training him, not through punishment, through waiting. Another notice arrives. This one confirms that prior measures will continue pending further evaluation. It references the absence of new objections as a factor. Daniel reads that line carefully. Absence of objection. He remembers the meeting, the pen on the table, the language about interpretation, the warning about delay. This is that delay. Daniel asks whether he can request a hearing to force a decision. He is told that hearings are scheduled based on necessity and availability. There is no indication that his case qualifies as either. Time stretches. Weeks now. Daniel notices how his days are structured around uncertainty. He plans cautiously. He avoids commitments. He waits for a call that never comes. The waiting becomes its own condition. Finally, an email arrives from the court administrator. It is brief. It states that because no formal objection has been filed and no new information has been submitted, the court will continue with the current course of action. Daniel reads it slowly. No objection. No new information. He understands the implication. Silence has been entered as consent. Daniel's attorney explains it plainly. The longer the delay, the more settled the situation appears. Reversal becomes harder not because of law, but because of optics. The system does not like to revisit what has already been normalized. Daniel asks when a final decision will be made. The attorney shrugs. Eventually. That word lands heavier than any ruling so far. Eventually means when there is nothing left to change. The record will show that Daniel Reyes was given time. It will show that he was not rushed. It will show that no objections were raised within the appropriate window. It will not show that the waiting itself was the mechanism. By the time Daniel understands what delay has done, the delay has already worked. Nothing has changed. That is the decision. Before the gavel fell.